Hello and welcome to ProfDale's Property video number 46. I'm your host, Dale Whitman. In this video, we're going to provide an introduction to zoning and land use planning law. Now in America, land use planning is mainly carried out by local governments. Federal and state governments don't do much land use planning. The most pervasive tool that local governments have to carry out land use planning is called zoning. But it's not the only tool. There are others as well. They include adoption of comprehensive plans, subdivision ordinances, site plan approval requirements, and the taking of title to property through eminent domain. We're going to begin our coverage with zoning. A workable zoning system requires the following elements. First, a state enabling act. That's a statute passed by the state legislature that authorizes cities and counties to adopt zoning ordinances. Second, each city or county that wants to do zoning has to adopt a zoning ordinance. Normally, that'll be adopted by the city council in the case of a city, or the county supervisors or county commissioners in the case of a county. We'll use the city terminology throughout here, but counties have essentially a mirror image of the same system. Third, we need a zoning administrator, a member of the local government staff who carries out and enforces the zoning ordinances. And fourth, we need some local commissions or boards. In addition to the city council, we typically will have a board of adjustment and a planning commission. We'll talk about their roles in a few minutes. Now, most states have both a city zoning enabling act and a county zoning enabling act. But these two are usually very similar. In fact, they're usually mirror images of one another. And both of them are usually based strongly on the standard state zoning enabling act adopted by the U.S. Department of Commerce nearly 100 years ago in 1924. It's remarkable the staying power that the standard state zoning enabling act has had. Some of the more famous provisions of the standard state zoning enabling act include the following. Zoning is to protect the health, safety, morals, and general welfare of the community. It governs the location and use of buildings, structures, and land. It does so in accordance with a comprehensive plan. Zoning must be uniform throughout each district or zone. The zoning ordinance is issued by the city council, the governing body of the city, after a public hearing and so many days of public notice. There will be a planning commission to recommend the boundaries of the zoning districts to the city council. A board of adjustment is created that may vary the application of the zoning ordinance. And practical difficulties or unnecessary hardship are required to be shown in order for someone to obtain a variance from the board of adjustment. A zoning ordinance consists of two major parts, the map and the text. The map shows the boundaries of the zoning districts. The text shows what may be done within each district. Here's a portion of an actual zoning map, this one for the city of Phoenix, Arizona. You can see that the map shows the boundaries of the zoning districts. They're marked in blue, and within each district there's an indication of the relevant zoning district, such as R5 or C2. Those letters and numbers refer to the text, and the text will tell us the allowable land uses and the height and bulk requirements for each of those zoning districts. In modern zoning ordinances, there are many districts. These are the ones for the city of Phoenix, and as you can see, there are about 50 different districts. However, they divide into some basic categories which are common to nearly all American zoning ordinances. There's single-family residential, multifamily residential, a separate set of districts for the downtown, a set of commercial districts, a set of industrial districts, and a floodplain district. Under the Standard Enabling Act, zoning must be in accordance with a comprehensive plan. So the concept is that a comprehensive plan precedes the adoption of the zoning ordinance. The plan covers land use, but it may cover many other topics as well, such as transportation, healthcare, housing, and so on. The plan is a general guide, and its land use element is much less specific than the land uses that are identified in the zoning ordinance itself. A formal written comprehensive plan isn't legally required in most states, but it is very, very commonly used, and in a few states it is mandated by the law. The plan deals with the physical development of the city or the county. It covers a long range, perhaps 5, 10, 15, or even 20 years. It contains a variety of policy statements, and it also includes a map or a set of maps. It'll be preceded by public hearings, and it's recommended by the Planning Commission and then ultimately adopted by the governing body, the City Council or the County Commissioners, for example. Typical comprehensive plan elements include land use, and the land use element will always include a map or a set of maps, housing, circulation, which refers to streets, and transportation, public facilities such as fire and police protection, recreation, environmental issues, energy conservation, open space, noise, and safety. Here's a portion of the map that corresponds to the land use plan for the city of Phoenix. As you can see, the number of categories is far fewer than you'd find in a zoning ordinance. There are about 20 categories on the land use plan here. Now we're going to talk about zoning in a little more detail. Zoning not only regulates land uses, but it also regulates height and bulk. Let's see how that works. Typical height and bulk controls include the following: front, side, and rear setback lines, that is, how far back from the boundaries of the lot must the buildings be constructed, maximum height limitations. Some ordinances have minimum lot sizes. Some ordinances may have minimum or maximum house sizes. There will be potentially a floor area ratio limitation, and we'll explain that in just a moment. You'll notice that there's a potential exclusionary effect from minimum lot size and minimum house size regulations. In effect, this may be a way of keeping poorer or lower income people out of particular parts of a city or county. Let's talk a moment about floor area ratio. To compute a floor area ratio, we take the square footage of the floor space in a building and divide it by the square footage of the lot that the building is situated on. It's quite a simple calculation. To illustrate, let's suppose we have a lot with a land area of 20,000 square feet. If we built a building of 10 stories and 10,000 square feet in each story of that building, we'd have 100,000 square feet. So to compute our floor area ratio, we'd take the 100,000 square feet of floor area in the building divided by the 20,000 square feet of floor area in the lot, and we'd have a floor area ratio of 5. That would be typical for a downtown office building. On the other hand, for a single-family detached house, the floor area ratio will normally be quite a lot less than 1, commonly in the range of 0.25 to 0.50. Again, we're just taking this floor area of the house and dividing it by the floor area of the lot that the house is situated on. Now, frequently when a landowner wants to change the way the land is being used, they will also need to change the way that zoning impacts on that parcel of land. And there are 3 different kinds of actions that are commonly used to change the impact of zoning. The first one is what we call a rezoning. A rezoning changes the zoning classification of a parcel of land on the zoning map. That means that, for example, we might go from an R5 to an R7 zone, or from a single family to a multifamily district. The second kind of change is a variance. A variance really gives permission for a landowner to violate the ordinance. Usually, in some minor way, they're permitted to do something that isn't normally allowed by the zoning ordinance. The third kind of change is a conditional use permit. That's a situation where even though the land's already zoned for the use the owner wants to make of it, he or she still has to obtain a special permit because the use that they want to make is considered sensitive or problematic. Now, once in a while, somebody wants to do something new with the land that is simply allowed by the zoning ordinance and no changes needed, and if that's the case, the administrator will simply issue a building permit for the new activity or change on the land. Now we're going to spend a few minutes talking about the structure of local zoning and the organizations that operate it. There are 4 basic bodies that you'll find in most cities and counties that deal with zoning. The 4 are, first of all, the City Council, which of course is an elected body. Second, the Planning Commission, which is appointed by the mayor or City Council. Third, the Board of Adjustment, which again is appointed by the mayor or the City Council. And finally, the Zoning Administrator, who is a staff person and employee of city government. Now we're going to take a look at the responsibilities of each of these bodies. First of all, the City Council, or legislative body of the local government. What does it do? Well, it issues the general or comprehensive plan, as we've already talked about. It issues the ordinances and the codes, such as the building and housing codes of the city. It approves rezonings. It approves subdivisions if someone wants to subdivide their land, and it may approve some conditional use permits. The Planning Commission's duties are mainly advisory. It recommends to the City Council the general plan, rezonings, and subdivision approvals. It may also have an independent authority to approve some conditional use permits. The Board of Adjustment's main job is to issue variances that are requested by landowners. It may also have authority to approve some conditional use permits. The Board of Adjustment also acts as a kind of appellate body, hearing appeals from the Planning Commission and from the Building Inspector's office. If a party is dissatisfied with the results of that sort of appeal, the party can take a judicial review to the local trial court. The zoning administrator's main job is to issue building permits after reviewing the plans for new construction. But the administrator also is responsible for prosecuting violations of the zoning ordinance by landowners. The staff of the planning department is going to be giving advice to all of these bodies. So whenever you see a meeting of the City Council, the Planning Commission, or the Board of Adjustment, you'll almost always see at least one member of the staff there to guide them through the decisions that they need to make. The zoning game is a complicated one, and in any given decision there frequently will be multiple parties who will be trying to influence the outcome. Usually there will be a developer or landowner who is the proponent of a particular change in the system. Then often the neighbors will be opponents of that change because they don't want to see any change made in their neighborhood. There may also be pressure groups such as environmentalist or preservationist groups who have an interest one way or the other in the outcome of the decision. The professional staff will have their input and frequently will express it in a very forward manner. And finally, there will be the elected or appointed officials who have to make the final decision. Now, you'll remember we said earlier that there are 3 basic kinds of decisions that are made in the zoning system: rezonings, variances, and conditional use permits. We're going to explore each of those in some detail, starting with rezonings. A rezoning is usually an amendment to the map to change the zoning classification of a particular parcel of land from one zoning classification to another. As we said, it might go from R5 to R7, or from a residential zone to a commercial zone. Usually just a single parcel of land is involved. Once in a while, there will be a requested amendment to the text of the ordinance to expand on a particular permitted use. And even more rarely, there will be the creation of a new zoning district. And once in a while, the entire zoning ordinance may be subject to a wholesale revision. But those are rare occasions indeed. The typical rezoning looks something like this. The owner of a particular parcel of land, in this case, is zoned R3 for 1 to 3 family and townhouse residential, and the owner requests a rezoning of that parcel from R3 to R5 that would permit mid-rise multifamily residential instead. The rezoning process looks like this. Usually, the initial request is by the landowner who wishes his or her land to be rezoned. Occasionally, there will be a request by the neighbors instead. First, there will be consideration by the Planning Commission, and they'll hold a public hearing on the issue. Then they'll make a recommendation to the City Council. The City Council will have another public hearing and consider the Planning Commission's recommendation. And finally, the City Council will make a decision and adopt a resolution if they decide to go along with the requested zoning change. One type of rezoning that is said not to be legally permitted is called spot zoning. Let's imagine that we have a lot, the one that the arrow is pointing to there, that's initially zoned residential just like all of its surrounding lots. But the City Council rezones it commercial or business use instead. Well, that looks like a strange decision, and the court might find that it isn't on the basis of any comprehensive plan because that one lot is treated so differently than its surroundings, and therefore the court might slap the spot zoning label on it and strike that decision down. Traditional spot zoning is represented by the diagram on the left on this screen. The spot is zoned for more intense use than its surroundings, such as a commercial use in an area that's generally zoned for residential uses. If the court finds spot zoning here, the remedy is that the court will strike down the upzoning and return the land to the same classification as its surroundings. On the right, we see the opposite, reverse spot zoning, where the spot has been rezoned for less intense use than its surroundings. Once again, if the court finds spot zoning, it will provide the remedy of upzoning the land to the same classification as its surroundings. In both cases, courts display a real hostility to spot zoning. Our next topic is variances, that is, cases in which a landowner goes to the Board of Adjustment and asks for permission to violate the ordinance in some usually fairly minor way. The typical Zoning Enabling Act draws its language about variances from the old 1924 Department of Commerce Standard Act, and it says something like this. To give a variance, there must be practical difficulties or unnecessary hardship relating to the construction or alteration of buildings or structures or the use of the land. The spirit of the ordinance should be observed, public safety and welfare should be secured, substantial justice should be done. A vote of 4 of the 5 members of the Board of Adjustment is required in order to gain a variance. As defined in the statutes of a lot of the states, there are 2 different kinds of variances. First, there are use variances. They authorize the use of the land for a purpose that's not allowed by the ordinance. The second kind is the area variance, which authorizes the use of the land in a manner not allowed by the dimensional or physical requirements of the ordinance. In general, what that means is that bulk, height, setback requirements may be varied in an area variance. About half the states don't recognize use variances at all, and the standard for issuing a variance in the states that do have use variances may depend on the type of variance the landowner is seeking. For a use variance, there's considered to be quite a high standard, namely unnecessary hardship. For an area variance, the standard is a lower one, practical difficulty. So in general, it's easier to get an area variance than it is to get a use variance. The third kind of zoning procedure that we need to talk about for a few minutes is the conditional use permit. A conditional use permit says the ordinance recognizes the use you want to make of your land as a permitted use in this district, but you still have to get a special permit before you can use your land in that way. By the way, conditional use permit is only one of the terms that's applied to this kind of proceeding. In some states, it's called a special use permit or a special exception. All of those 3 terms have exactly the same meaning. The permit may be issued by an administrator, that's not too common, by the Board of Adjustment, by the Planning Commission, or by the City Council. And in some cities and counties, One type of conditional use permit may be issued by the Board of Adjustment or the Planning Commission, and another type by the City Council. So you just have to read the ordinance to see who's enabled to issue this particular type of conditional use permit. The ordinance has to contain standards to apply to the application, standards that indicate when and whether a conditional use permit is to be issued. Common conditional use permit situations. I won't go through all of them here, but you can see that among the more common ones are cell towers, drive-in businesses, duplexes, home occupations, churches, schools. All of those are typical conditional use permit situations. The concept of the conditional use permit is something like this. The type of use you want to make can fit comfortably into this zoning district. However, there are some aspects of it that are problematic, and therefore we may need to impose conditions on your use in order to minimize those problems, and that's the purpose of your having to get a conditional use permit. When the decision-making body acts on a conditional use permit, they have several possible choices. They might simply reject the application, telling the landowner, sorry, but you are not going to be allowed to make this use of your land at all. They might grant the application with conditions, and that's probably by far the most common outcome. In theory, they might grant the application and not impose any conditions, but don't bet on that. Once they have the opportunity to impose conditions, the temptation to do so is almost irresistible. Notice that imposing conditions may quell neighborhood opposition. Conditions about lighting, signage, visual sight lines, landscaping, berms, all of those things may convince the neighbors they really don't object to this project so much anymore after all, and that may make the decision much easier for the decision maker. Typical conditions on a conditional use permit relate to parking and access, landscaping, building size and placement, architectural style, signage, lighting, hours of operation. It's not unusual to have a large number of conditions. I remember seeing one on a Walmart where there were more than 100 conditions imposed on the conditional use permit, and having 10 or 20 conditions is pretty much par for the course. As a practical matter, the developer has to agree to the conditions. If the developer doesn't agree, he or she will simply withdraw the application and come back and try again later, or give up on that particular form of the project. The conditions are often recommended by the planning staff, and they may also be demanded by the neighbors. They may be very heavily negotiated, so there may be a lot of behind-the-scenes discussion about the exact wording of the conditions before they're put in the form of a formal resolution and voted on by the decision maker. Now that we've covered both conditional use permits and variances, it's interesting to compare the two. First, a conditional use permit. It applies only to changes in use. There's no necessity for a proof of hardship on the part of the landowner in order to get a conditional use permit. The owner has the right to the permit if the ordinance's standards are met. The system of conditional use permits is built into the ordinance's district classification scheme. It's part of the system. The city obviously can attach conditions in a conditional use permit. Now, variances, they can apply to either changes in use or changes in bulk, such as area and height. They do require some degree of proof of hardship or practical difficulty. They are discretionary, and the owner has the right to a permit only if the city has abused its discretion. That's hard to prove, so it's very difficult to get a variance from a court if the city has turned you down. The whole system of variances is outside of the ordinance's district classification scheme. In other words, it isn't built into the ordinance that you need a variance for certain kinds of uses. They're purely ad hoc. Finally, it's unclear whether the city can attach conditions. The Standard Enabling Act doesn't say that conditions can be attached to a variance, as it obviously does with a conditional use permit, but probably the courts will allow variances to be issued with conditions attached. In addition to zoning, cities and counties have some other land use tools available to them as well. and we're going to cover a few of those now. The first is, as we've already discussed, the comprehensive plan. The plan is prepared and recommended by the Planning Commission, and then it's adopted and promulgated by the City Council. It's a guide to future land use planning decisions. And even though it isn't legally binding in and of itself, in many states it is required that zoning decisions be in accordance with the comprehensive plan. A second tool is the Subdivision Ordinance. The ordinance will set out standards for subdivisions. How large should the lots be? How wide should the streets be? Will curb, gutter, and sidewalks be required? What about the curvature of the streets? What about the paving material? All of these matters will be set out in the standards in the ordinance. Initially, the approval is by the Planning Commission, but the Planning Commission will then send the subdivision plat on to the City Council for final approval. And when the City Council makes the final approval, it will be accepting the dedication of the streets and other public easements that are shown on the subdivision plat. That means that now the city will be responsible for the repair and maintenance of those streets and other public easements. Site plan approval ordinances are another tool in the arsenal of local governments to supervise the development of land. Usually, these approvals are required only for large-scale projects, such as shopping centers, hotels, large office buildings, and so on. The developer will be required to submit a site plan showing the buildings, the landscaping, the parking, the entire layout of the project, and the approval will be given either by the Planning Commission or the City Council. Finally, local governments have the power of eminent domain. That means that they can acquire title to land even if the private owner doesn't wish to give it up. Of course, they do have to pay fair compensation to the owner who is losing title to the land. Takings have to be for a public purpose. Common purposes are for street creation or for street widening, for building new public buildings such as a fire station or police station, or for redevelopment, which may involve clearance of substandard properties and slums. We're going to wind up by taking a brief look at regulatory takings. These cases ask the following question. Could a zoning or other regulation be so severe in its impact on a parcel of land that it is deemed to be a taking, requiring the local government to pay compensation to the landowner? The answer is yes, that is possible, and the Supreme Court of the United States has outlined when it can happen. We'll look at that on the next slide. The court has indicated that there are three theories under which a regulatory taking might be found, and therefore in which the government might be ordered to pay compensation to a private landowner. The first of those is called a Loretto taking, and that's where the government authorizes a permanent physical occupation of the land. Now, the occupation doesn't have to be very extensive. In the actual Loretto case, it involves simply some metal boxes and some wires in order to wire an apartment building for cable TV. But the court nevertheless said it was a permanent physical occupation, and that meant that the apartment building's owner was entitled to compensation for that invasion. The second kind of taking is a Lucas taking, and that's where the regulation doesn't involve a physical invasion of the land, but it does deprive the land of essentially all of its economic value. So the regulation has to be so severe that basically the land has to become valueless, and there the landowner is entitled to compensation. The third kind of taking is the hardest one to identify. It's called a Penn Central taking, and it requires the court to weigh three factors. The first one is, what is the character of the government's action? Is the government physically invading the property or merely regulating it? Second, what's the degree of economic impact? If the impact is not 100%, that is, it's not a Lucas taking, the government hasn't taken the entire value of the land, is the government taking a large share of the economic value of the land? That might be enough to constitute a taking. Third, the court has to consider whether the taking is an intrusion onto the owner's reasonable investment-backed expectations. Did the owner have any reason to expect when acquiring the land that this sort of taking would occur? So those are the three Penn Central factors, How they weigh against one another is not very clear, and the cases are really hard to characterize. That concludes ProfDale's property video number 46 on zoning and land use controls. If you have questions or comments, please email profdale01@gmail.com. Thanks for watching.